attend both. We really just schedule 2 meetings to provide greater flexibility for those who want to attend. You might also notice that Daniel Jacobs is listed as the rules coordinator, and although he is currently on leave, he is integrally involved in this project and will be resuming the lead when he returns in a couple of weeks. So if you direct questions and comments to rules@lcb.wa.gov, that's going to be your best way to make sure that both he and I get them. Our objective here today is to obtain public feedback on the updated draft rule language for retail alcohol product placement rulemaking. And once again, the best way to get in touch with us with questions or comments is rules@lcb.wa.gov. And just a few housekeeping notes before we get started. During the meeting, please keep the following in mind. These sessions will be recorded and are subject to public disclosure. The purpose of the recordings is to make sure we collect all feedback, and these recordings will be posted on the rules webpage. While the Teams chat feature is on, any written questions submitted in chat will be saved in the rulemaking file and are subject to public disclosure. Questions and comments in the session's team chat will not be responded to in real time, but will be addressed at the end of the session, time permitting. Participants will be muted and will only be unmuted when the facilitator enables their microphone. To ask questions during the sessions, participants must use the raise hand function and they will be unmuted to ask questions. And if you would like to submit questions before, during, or after today's session, feel free to email the rules team once again at rules@lcb.wa.gov. So before we get into the updated draft rule, many of you want to know specifically where we're at in the process here. So we're going to look at the timeline here. You'll see that in January, we filed the CR 101. That is the pre-proposal statement of inquiry, notifying the public that we are considering rulemaking on a given topic. We held 2 stakeholder sessions back in March. Those were centered around the first initial draft that we released in this effort. And since that time, we've heard from stakeholders, and we are here today with a second draft to discuss that today and on Friday. And then looking forward, we're tentatively looking at filing the CR 102. That's the official rule proposal on November 5th, which in turn would trigger an official public comment period from November 5th to December 11th. And the public hearing would be held on December 11th. And then assuming that we didn't need to make any changes to the draft rules at that point, based on stakeholder feedback, we would be in a position to file for official adoption of the draft rules on January 7th, which would make the rules effective on February 7th. You may note that we had initially indicated that we would be finished with effective rules by January 1st. However, because the rules team has been inundated with rulemaking work required by legislative changes that are on a rigid timeline, we had to reprioritize, and this project got pushed out a little bit. That being said, this project is still really important to us, and we're not too far off from where we initially thought we'd be with rules tentatively in effect by February of 2026 now. So you can find the latest draft, which has been updated since the first draft, at the link here. That will actually take you to our current rulemaking page with all of our rules. So you would just look for retail alcohol product placement and click on that. You can find the latest draft. You can find the first draft, the recordings of previous stakeholder sessions, and all of the pertinent information like filing documents and that sort of thing. So today I'm going to briefly review why we're doing this rulemaking and who it applies to. And then we'll go over the key changes in this latest version of the draft rules, which again have been updated in response to stakeholder feedback from the first draft that we issued at the beginning of the rulemaking project. So this is just a review of the goals we discussed at the last stakeholder session. Nothing has changed here. The LCB has heard from folks increasingly over the past couple of years with concerns surrounding what we're calling crossover products. These are products containing alcohol that share branding or logos with non-alcoholic beverages. So for example, like hard Mountain Dew or canned Jack Daniels and Coca-Cola. And the concern stems from the confusion that can result when these products are marketed alongside their non-alcohol counterparts. There have been cases reported where someone who didn't want alcohol accidentally bought a product that contains alcohol. And we've even heard some reports anecdotally where an adult accidentally gave alcohol to a minor because they didn't realize the product contained alcohol. We've also received a number of comments over the years regarding concerns with how alcohol is displayed in a retail environment and its impact on youth access and the recovery community, as well as its impact on responsible consumption habits of consumers who are of age. And most recently, we've also heard from people with concerns about increasing incidents of minors shoplifting easily concealable mini bottles of liquor located predominantly near store entrances and exits. So we're looking at number one is reducing confusion between alcohol and non-alcohol. Number two, reducing theft, and number three, reducing youth exposure. And those 2 and 3 there are somewhat intertwined in this case. And of course, these goals are aligned with our agency mission to promote public safety and public health. So before we get into the draft and the key changes and so forth, I'm gonna show a few slides with some examples of the kinds of things that we're talking about here. So in this one, you can see we've got the rum and the whiskey next to child's candy and fruit snacks. We've got in the center hard Mountain Dew being marketed right there with Kool-Aid, which is a product that appeals predominantly to children. We've got frozen cocktails next to Astro Pops, another product that appeals to children. Got a few more of these slides here. We've got a wine display case next to M&Ms. We've got ready-made cocktails next to fruit by the foot and other kids snacks and candies. We see on the left here a display of mini bottles of Jack Daniels, and I believe that is Jameson whiskey there. We've got another one of Buzz Balls in the middle, unsecured minis that are, in this case, particularly accessible to smaller people like children. And then we've got mini bottles displayed openly on a counter there. We've got peppermint vodka next to a bunch of holiday candy that's appealing to children. We can see the Hot Wheels toy cars. They're displayed immediately above the hard Mountain Dew. And then on either side here, you can see the ping pong balls. We all, I think, understand the association there. And then in the middle, we have Hot Wheels once again next to an alcoholic seltzer. So who exactly will these new rules apply to? We're looking specifically at specialty shops, grocery stores, and spirits retailers. And there are a few different licensing variations there, but those are the 3 categories. So getting into the stakeholder concerns, things that we heard from the public after our last stakeholder sessions. we held the sessions just like we're doing here today, and we included some concepts in the first draft, essentially as a starting point for conversation, with the understanding that the final rules would likely contain some significant changes. And we received a lot of really great feedback expressing a general consensus in some areas, as well as some real disagreement with our approach and noted pain points in other areas. So the key concerns that we recorded can be summarized as follows. First of all, the floor displays and end caps are critical for consumer awareness in a marketplace with so many options. Prohibitions would have a disproportionately negative impact on smaller local producers. We also heard that smaller stores may not have the space to fully separate alcohol from non-alcoholic products, and prohibiting alcohol from being displayed in areas near checkout stands could actually have a negative impact on anti-theft strategies, which is exactly the opposite of what we had intended to do. We also heard that different rules for licensees over and under 2,500 square feet creates confusion. Uniform rules for all licensees would be easier to follow, but if a distinction must be made, 25 square feet might not be the right answer there. We heard kind of more on a philosophical level that Washington voters decided that they wanted to be able to purchase liquor in grocery stores back in 2011 with the passage of I-1183. And so significant limitations on customer access in this environment stand in opposition to the spirit of that initiative. And then further, we heard that some of the terminology needs to be more clearly defined and some of the concepts could be better articulated. In addition to those concerns, we did receive a significant amount of agreement on some things. In particular, we heard that many bottles located where they can easily be stolen is problematic. Businesses, of course, have their own incentives for reducing shrinkage, but the state has a particular interest in the shoplifting problem when this becomes an avenue for minors to access age-restricted products. And we heard from many, both within the industry and on the public health side of things, questioning the marketing strategy behind some of the products that almost seem to be designed specifically to appeal to youth. So crossover products displayed near their alcoholic counterparts can cause confusion and potentially encourage youth consumption. And overwhelmingly, I think everyone's on the same page that ensuring that minors cannot access alcohol is a top priority. So in response to the feedback that we heard, we made several changes to the draft. So number one, we recognize that there are just some fundamental logistic and spatial differences between a corner convenience store and a full-scale grocery store, for example. So while we wanted to simplify the rules so that they'd be easier to follow, we still wanted to carve out a certain accommodations for smaller stores given their limited space. So we restructured the rule to apply to all specialty shops, grocery stores, and spirits retailers, with additional accommodations for those under 5,000 square feet. We also heard from many stakeholders within the industry who are seeing a significant decline in sales, reflective of societal trends towards more moderate alcohol consumption in general. And resoundingly, producers rely now more than ever on in-store displays, including end caps, to stay relevant in a competitive marketplace. So we removed the language broadly prohibiting any alcohol in end caps and displays, but we kept the limitations on crossover products being displayed near their non-alcoholic counterparts. And we eliminated the prohibition on alcohol displays near point of sale or checkout stands. And this goes back to the comments that we heard about how some stores display alcohol near checkout stands specifically because store employees are better able to keep an eye on it there. And this is a deliberate strategy, so we didn't want to stand in the way of best practices regarding anti-theft efforts. We also clarified which non-alcoholic products must be separated and provided exceptions for things like bottled water and mixers. And we updated the definitions and modified the rule language for greater clarity. So with that, I'm going to share the updated draft on my screen here. We'll go over the whole thing. Fortunately, it's only about a page, a little longer than a page. So we should have plenty of time for questions and comments after that. So hang on for just a moment here while I switch what we're looking at. Okay, I'm gonna make this a little bigger so you don't have to squint to read it. I think that should do. All right, so first, we put the definitions up front just to be clear with what we're talking about. So that's a slight change from before. And we get into a definition of crossover product, which is new. We didn't actually define that in the first draft. So a crossover product means an alcohol product containing the same or similar brand name, logo, or packaging as a non-alcoholic beverage. In cap, we had that in the previous draft, means a display for products placed at the end of an aisle. Then we also have a new definition for low or non-alcoholic alternative beverages. That means beverages that have less than 0.5% of alcohol by volume that are marketed to adults as alcohol beverage substitutes for beer, wine, and spirits, including but not limited to products marketed as near beer, low or non-alcoholic beer, seltzers or wine, non-alcoholic cocktails, sometimes referred to as mocktails or virgin cocktails, or other products marketed as alcohol substitutes. Then we kept the same definition for mini bottles. That's any alcohol container under 200 milliliters or 200 milliliters or less. We kept the reasonably secured definition, including but not limited to the following individual theft prevention devices attached, secured behind the counter, secured in a locked cabinet, or secured in a manner out of reach of shoppers. And then we kind of restructured here that, like I was talking about, section 2 here is who the rule applies to. And we, just to make it a little bit more clear, just recategorized into those 3 primary groups: specialty shops, grocery stores, and spirits retailers, and then further defined those in this section here. And then let's see here. So section 3, this is where we kind of changed it up. Rather than bifurcating the rule into 2 sets of rules, we just lay forth what is required, and then at the end of the rule, we have some essentially exceptions for smaller stores that are 5,000 square feet and under. So 3A1, no liquor products containing 0.5% of alcohol by volume or more may be displayed next to soft drinks, soda, fruit juice, energy drinks, liquid tea, flavored water, candy marketed for youth consumption, food with cartoon or youth-oriented images, toys, games, and related gear, and items marketed for youth consumption. And then A3A2, the following may be displayed next to liquor products containing 0.5% of alcohol by volume or more, and that would be your low or non-alcoholic alternative beverages, which we defined above, and bottled water. And then 3A3, the following liquor products containing 0.5% of alcohol by volume or more are not subject to the restrictions above in A1 of this subsection. And so that sets an exception for mixers, bitters, and cooking wine and that sort of thing that are not subject to this rule. And then moving on here, B, crossover products will not be displayed in the same aisle as their non-alcoholic counterpart. C, crossover products must not be displayed on end caps or freestanding displays unless the aisle or broader area of the retailer is dedicated solely to the sale of alcohol. D, many bottles of liquor must be reasonably secured at all times, which I believe is the same as, yeah, that was the exact same as our first draft. Again, we had pretty broad consensus on that one. And then moving on to 4 is where we carve out the accommodations for smaller stores. This says specialty shops, grocery stores, and spirits retailers with premises under 5,000 square feet must comply with the following. The requirements in subsections 3, B, C, and D of this section. B1, liquor products containing 1/2% of alcohol by volume or more will be physically separated from the items listed in subsection 3A, 1A through I of this section. And then B2 there allows for these entities that are 5,000 square feet or smaller to comply with that by posting signage if they don't have the space to accommodate that requirement otherwise. And so a sign would have to be placed in a clearly visible place that reads, "These products contain alcohol and are only available for sale to people 21 years of age and older." And then the penalties would be the same as they previously were there. So that covers the rule. As I said, it's a pretty short one here. I am going to ask Tierney to go ahead and open up the chat. And if anyone is interested in raising your hand and asking questions, or if you have comments, we'll go ahead and get started with those. I can't see what's going on while my screen is shared, so I'm going to stop sharing, but we can pull it up again if we need to. All right. So I see, Aaron, that your hand is raised. Tierney, could you?
Yeah, thank you. Can you hear me?
I can, yes, thanks.
Perfect. Good afternoon. Thank you for the opportunity to ask some questions. I realize the Washington Liquor Cannabis Board has broad regulatory authority to oversee the sales of alcoholic beverages in the state of Washington, and obviously protecting youth is a priority. I share your desire to protect youth from harm, but I had a few concerns related to the evidence in support of this particular proposal. Now, my question, this proposal would add restrictions to where alcohol can be sold, namely by banning alcohol from being sold near soda, juice, and other commodities that your office might deem as youth-oriented. I had a call with your staff to discuss this proposal, and your staff indicated at the time they had no information that showed that alcohol sold near these commodities had any negative health impacts on youth. And additionally, I've studied the topic extensively, and I'm not aware of any peer-reviewed study that has concluded that alcohol sold in proximity to these other commodities is harmful. Even in this state, the proposal will have negative financial impacts on retailers, distributors, producers, and of course, state tax revenues as a result. Given the lack of evidence that alcohol sold near these other commodities is in fact harmful, what public health metric do you believe this proposal will improve, and what are you basing that belief on?
Well, thank you for the comment. Yeah, I mean, I think that the research is probably limited, but again, we have a responsibility to respond to feedback from our constituents, from anyone in the state of Washington. There have been concerns around these issues expressed, and we're looking at finding low impact ways of addressing those concerns. You mentioned that there could be an economic impact. I'm not aware of any peer-reviewed research that would indicate that there would be a significant economic impact. Kind of conversely,
I might counter that. I'm sorry to interrupt, but the research that you cited showed specifically that displays increased velocity of sales, and by limiting display locations, that would in turn, reduce the number of displays total that are happening in a store at any given time, which would have the opposite effect of slowing sales. So my next question was going to be if any financial analysis had been conducted to see what the potential impacts of this would be to, again, retailers, producers, distributors, et cetera. But I'm going to assume that has not occurred. Is that correct?
That is correct. We have not done an economic analysis. I think it's pretty likely, based on the requirements of the APA, we would have to look and see whether that was required or not. But in many cases, we go ahead and do that kind of economic analysis anyways, whether it's a legal requirement or not. And I think in this case, given the concerns that you've raised, that's something that we would take under serious consideration before we would advance to moving with an official rule proposal here.
Okay, I have two other quick questions, all related. On that same call, we were talking about theft, and your staff indicated that there was no data on theft rates, not how often it's occurring, from where in the store it's occurring, or even what formats are impacted. Same general question, we're trying to reduce theft. How would we even measure whether we were successful in doing so if we don't have a baseline today? And how are we, determining which formats we're targeting other than anecdotal evidence?
Yeah, I mean, I think that's a valid question. I mean, we always want to make data-driven decisions to the extent possible. We don't always, hear when theft is happening. Retailers don't always report that. I mean, we know that in our state and elsewhere, shoplifting is something that is not always pursued. I mean, those are corporate policies, so we're not getting data on that. But we have heard from a number of stakeholders indicating that this is a problem. I think that there's a general awareness of that throughout the state. Shoplifting is on the rise. I think most retailers would agree with that. And we're continuing to look for data that would support this. But again, we do have broad regulatory authority here, and we're looking at minimally impactful ways that we can address issues that people are concerned with here.
Indeed. And I might just add that at least research indicates that less than 1% of the alcohol obtained by minors is obtained via retail theft. The vast majority, like 95% plus, is coming from legally purchased alcohol supplied to them by, people who bought the alcohol, adults, for whatever it's worth. And then my last question was in relation to crossover brands. There's some prohibitions here that would target specific subset of brands, but there's no intrinsic difference between, say, a Hard Mountain Dew and, say, White Claw or Mike's Hard Lemonade or any other brand. And is that not a violation of the brand's First Amendment protections to not be discriminated against based on packaging or branding? I mean, it's all legally approved packaging. Is there not a concern there that creating an arbitrary subset that's not defined by any TTB definition could pose legal ramifications?
Yeah, I don't know if I would consider that completely arbitrary, the distinction there, because you're looking at products that already exist on the marketplace, like Coca-Cola, for instance. It's one of the most universally known brands that exists, and it's a product that families consume regularly. And then when you throw Jack Daniels in the mix, but you prominently see Coca-Cola displayed on the label, it's a potential to create confusion. So, this is something that's been done in other states. Before we finalize anything or adopt any rules, we're going to get input from our attorney generals regarding any questions of a First Amendment violation there. But so far, that's not, we don't see it that way.
I see. Okay. Well, thank you for that feedback. And I guess I'll just end on a couple of just other stats. I'm sure you're already aware that youth consumption is down 67% since 2010, down binge drinking down 75% since 2010. So again, some substantial, in fact, that's a larger reduction than occurred during Prohibition. So again, we're at, I think, about the lowest rate of youth consumption that's ever been recorded in the state of Washington. And so again, just kind of questioning the timing and purpose of these rules if they're actually necessary.
Okay, we really appreciate your comments, Aaron. Thank you.
Andrea, you should be able to unmute your microphone.
Hi, thank you.
Hi.
Andrea McNeil, I'm with the Wine and Spirits Distributors Association in Washington. And we also appreciate the opportunity with the LCB to have these stakeholder sessions and offer some feedback and questions. Just primarily a couple of comments. I remember being involved in some original conversations a couple of years ago around crossover products with some of the LCB folks. And the focus at that time really was confusion, consumer confusion about products that look similarly to alcoholic products. And I'm wondering on the end cap, I mean, I think the point that you raised at the beginning was well taken about Washington citizens wanted to be able to purchase alcohol in grocery stores. And if it might be possible to address the concern about confusion with end caps with a sign similar to what has been proposed for the stores under 5,000 square feet. And so the end cap would still be available, but there would be signage that would allow folks to know what they were purchasing.
Thank you for that, Andrea. We will take that under consideration as we move forward with this rulemaking.
Right. And just one other comment too. I think I had some concern both as a consumer and as in this role with the definition of youth-oriented products.
Okay.
I know that could be pretty broad, and I think it's a bit vague. It does that include sports gear? Does that include, a basketball? Does that include things that aren't necessarily youth-oriented? I think that is worth looking at more closely and trying to narrow down exactly what is youth-oriented.
Okay, we appreciate that. I will say transparently, in rule, it's kind of hard to get at what we were trying to accomplish here with the youth-oriented products. Saying that you can't have hard seltzer next to Skittles and Starburst, but you can have, I don't know, L'Ecole number 41 Syrah next to Theo's chocolates. Like, how do we get there in rule? And so we tried to take a minimally prescriptive approach here, but we are certainly open to feedback and suggestions for improvement. So we thank you for those comments.
Yeah, you're welcome. I appreciate the chance to offer them.
Thank you.
Carolyn, you should be able to unmute your microphone now.
Hi, thank you for the opportunity to comment. I'm Carolyn Loga here representing the Washington Food Industry Association. I think you'll be hearing it from us quite a bit on this subject, but also we'll provide written comments as well. Just a couple of things. First of all, really appreciate the changes you did make and that you listened to us on those. I think we still have some questions. First of all, if the product is locked up, is there any way to provide an exemption for that? If a store does lock up the entire scope of their alcoholic products, I mean, other than beer and wine. But the other thing is a lot of concern about the size of mini bottles defined in here. 200 milliliters is a half pint, and mini bottles are traditionally defined as the 50 milliliter bottles. So a lot of concerns about that still. And then we're still trying to figure out if our convenience stores and our smaller stores will be able to comply. I'm looking at the sections on those, and I'm not exactly sure it's clear if they label the product, can they have it in the same aisle? If it's an end cap, could they have other products in the same aisle? So there's a lot of, I think, some questions still about how that would actually work in application within those stores.
Okay, we really appreciate those questions and comments. I think the idea here was that we understand as the convenience stores in particular have very limited space, and so we wanted to kind of pull away from those more restrictive requirements and just allow signage to take the place of those of actually separating the products. But if the rule doesn't read that way, or if it's not clear, then you know, we certainly could consider some changes to make that more clear.
I think that's maybe what we would be looking for, and we'll try to provide some suggestions as well.
Okay, great. Thank you.
Josh, you should be able to unmute your microphone.
Great, thank you. Hi, Kevin.
Hi.
Josh McDonald here, Washington Wine Institute. Appreciate the opportunity to comment on this next set of draft rules. Want to thank you and your team for taking all of our input and really taking it seriously and making fairly substantial changes from the first draft. We see that as a great sign of taking in our feedback and actually, you know, changing towards things we think you were really trying to hone in on as concerns from the agency versus concerns about how, you know, well, end caps and everything else, and capturing how, you know, we represent the Washington wine industry, how those things are so vital to us. So really appreciate that your team looking at that. So largely just have one question / potential concern here, and that is, could you help me understand the for mini bottle definition, the 200 milliliter and under? Why is the I asked the question because we don't have a lot, but there are some local wineries that use the 187s for their packaging. Not much, but some, and we'd be a little concerned if you know. And I think you're going after these mini spirits bottles and concerns around there, but those are much smaller than 187. So could you talk a little bit about that? And just want to give you that feedback.
Yeah, I know there was significant conversation around what the appropriate size would be at the beginning of this rulemaking project, and admittedly, I was actually not a part of it at that time. But as I understand it, you know, as you mentioned, I mean, there are some products that are, you know, utilizing a 187 milliliters, I believe you said, that are, you know, small enough that you could put in a pocket, that, you know, we believe there could be a potential for theft there, just like there could be for the 50 milliliter bottles. But, you know, if this is something that's concerning to you, I mean, we will certainly reevaluate that and take a look at whether changes are warranted there.
Yeah, thank you. Appreciate the feedback on that, and again, appreciate the opportunity to comment today.
Thank you so much.
Crystal, you should be able to unmute your microphone now.
Thank you. My name is Crystal Leatherman. I'm with the Washington Retail Association. Just echoing others' comments about really appreciate you taking our feedback and you know, updating and trying to limit the scope of what this rule will look like. I will be submitting written comments. Previously, I submitted for the last round, and I'll do it this time as well because I represent such a broad industry. Just the impact and implication of these rules on different store types, whether it's large, you know, warehouse style, you know, retailers or small specialty shops. So I'll make sure to provide that to you in written comment. But I do want to also echo the concern around the definition of what a mini bottle is, the 200 milliliter. Won't go into too much detail about that. It's similar to what has been stated already. I do think that we would like to talk about defining what an aisle is. Again, when we're talking about retailers, there's some larger retailers who they have a larger aisle space, and that's more space that they may not necessarily fill up with alcohol product. And that there might be, you know, other food items along that aisle that I think need to be taken into consideration. Also, just on the freestanding and the freestanding displays and the end caps. Again, we understand the goal is not to mix crossover product, but I there is instances where consumer or the retailer or their supplier may be setting up certain types of displays according to the holiday or sporting events. And again, they might have limitations on the size of their store on where they can place those freestanding displays. So just maybe trying to narrow that down even further. I also just want to just point out that there, again, while we do appreciate and recognize that that a lot of changes have been made and you've taken a lot of feedback, that there are still some concerns with this. I would like to request that there's some consideration on limiting the scope even further, on just limiting the crossover product not being displayed in a non-alcohol aisle for stores of certain sizes, and then also ensuring that there's, like, if it's something that is explicitly marketed or targeted towards children, whether that's cereal or, you know, fruit snacks or things with cartoon or licensed images on it, that, you know, maybe we narrow the scope down to that to help limit the influence that these products could have on youth. But again, really do appreciate the work that you've done so far, and looking forward to working with you further.
Thank you, Sally.
Okay, there we go. Hi, I'm Sally Jefferson. I'm with Wine Institute. We represent over 1,000 California wineries of all sizes, and I'm their director of Western States region. We really do appreciate the LCB's stakeholder outreach on this issue and developing these rules and the significant changes from the original language, particularly with regard to end caps and freestanding displays. But I'll echo similar concerns about the breadth of the proposal with regard to mini bottles and the restrictions that would be imposed on really a large category of products that it would cover. So from a winery perspective, as it's defined, it would cover 187 milliliter containers of wine, which come in various forms of packaging, including glass, aluminum cans, plastic, and Tetra Paks. And while they may be sold in singles, many times they're sold in packs ranging from anywhere from 4 to 6, similar to how beer is packaged and sold. And they're growing in popularity given their convenience. You know, they're ideal for adults who want to enjoy a smaller amount, you know, a smaller format of wine, and so that they can have it with a meal, because they don't want to open a full, you know, 750 ml bottle. They provide accessible option for trying new wines without substantial investment of buying a larger format. They're also used at, you know, parties, corporate, and other public events for controlled portion sizes. However, you know, as it's currently written, you know, these products would be essentially required to be secured in such a manner that makes them out of reach to customers, which will ultimately restrict and reduce their sales. You know, many customers want to view the product that they're looking at purchasing and read its label. You know, but in order for them to do that, you know, they would have to get a retail staffer to help them, as well as to purchase these products. Presumably it would also not allow these products to be sold in cold boxes, and many times that they are. And no other state imposes such requirements and restrictions on 187 mils of wine. So again, it just kind of begs a question about, you know, why make it more difficult for adults that want the smaller format of wine for them to be able, you know, to get them. And if it is in response to theft and underage persons, then it would be helpful to know, you know, what specific products or specific categories that have been affected and have given rise to this issue, rather than having a blanket restriction on all products under 200 and less milliliters. But Again, we appreciate your willingness to look at this issue and look forward to working with you all in addressing these concerns. And again, we really do appreciate all the outreach and the efforts to work with the industry.
Thank you. And we definitely hear you. You know, there clearly is concern around that 200 milliliter. So that is something that we will evaluate and we'll continue to look at to determine whether changes are necessary there.
Carrie, you should be able to unmute.
Yeah, thank you. Hi, Kevin. I'm Carrie Tellefson, and I'm here on behalf of Republican National Distributing Company, which is a spirits and wine distributor. And I just wanted to echo the comments made by Andrea McNeely regarding end caps and, you know, the suggestion that an alternative might be to add a sign on the end cap to make it clear that that's an alcoholic beverage. So we'd just like to echo that and also ask for clarification around the issue of the definition of youth-oriented type products. Additionally, we have some concerns about product adjacency and, you know, you've got soft drinks and soda, you know, listed as something that can't be, you know, next to alcohol, yet those are mixers. And then you've got another reference to mixers. And so it's, you know, there's a little bit of a lack of clarity there. And I don't know, it just seems like something that needs to be further discussed. We'd hate to see, you know, not be able to display club soda or, you know, some common mixers that might not have the name mixer on the label next to an alcoholic product. So just like you to consider that if possible. And then just one other thing, in the penalty section, when I took a look at the WAC reference there, that chart, it's unclear in this draft which penalties would apply because there are kind of two different categories of penalties in that chart.
Mm-hmm.
And this, you know, I mean, I guess I'm assuming you're going to add another category that would be referencing this rule. But that's just a question I had there.
Yeah, so we have a separate rule section specifically for penalties, and we would have to update it based on and add this particular WAC, Washington Administrative Code, into that the penalties rule. So we will be looking at doing that when we move forward to the official rule proposal. But otherwise, we hear you. I appreciate those comments about you know, typical mixers, you know, potentially or unintentionally being restricted and that sort of thing. So we will certainly take a look at that as well. Thank you.
Appreciate it very much. Thanks.
Aaron, you should be able to unmute now.
Thank you. Thank you. I had one other quick concern, and that's that non-alcoholic brands such as sodas and candies can actually purchase their display locations from the store. That's something that's illegal for alcohol to do, but they actually get to select where and when in the store they're displayed, which the way this is written would give them the ability to target any alcohol display location and effectively kick us off the display by simply buying display real estate near our products. Has any thought, since again, they have the ability to choose where in the store they get displayed and when, to flip the burden on non-alcoholic brands not to be displayed near alcohol, since again, we don't get that choice, they do. Or again, just some consideration so that that isn't a strategy that could be employed, you know, again, by a soda brand to just simply target alcohol displays to garner more real estate space.
Yeah, honestly, that's not something that we had considered. So we appreciate that comment and we will look into that.
Thank you.
Carolyn, you should be able to unmute.
Sure. Thanks, Carolyn Logue again with Washington Food Industry Association. Just first of all, echoing what Carrie just brought up about the regular mixers. Some questions also about stores that might potentially only sell alcohol and if these would apply in those cases. And the other question is about holiday displays. You brought up the Theo's chocolates. Pairing some of those things specifically with alcoholic products in alcohol display containment, even boxes, gift boxes, and those types of things does happen. And is there a way to provide some opportunity to still do that? Because those are not marketed towards children. I mean, at Valentine's
Yeah.
Day, for instance. So,
Yeah, and I mean that's why we were trying to get at the definition of youth oriented. And I mean, it sounds like there's still some confusion there, and we probably have some work to do. But you know, products with cartoons on them and that sort of thing. I mean, it's a little bit challenging, and it's kind of that old like, well, I know it when I see it sort of thing, but how do you put that in rule, right? So, um, you know, during the last round of stakeholder sessions, people brought up, you know, seasonal wine pairings for Thanksgiving and things like that. You know, we certainly don't want to limit you know, wine and cheese from being paired together. That's like a traditional pairing. So that's not the intention here. You know, we were trying to get a little closer by defining youth-oriented products. But again, I think, you know, based on the comments today, we could probably refine that a bit further. And once again, I mean, any suggestions that anyone have, you know, particularly if you have specific rule language that you would like to suggest, that is often the most helpful. So we appreciate the comments, and we will continue to look into these things. Was there another question that I didn't answer there? I'm sorry.
no, I think that was it, because I was just when you brought up the Theo's chocolates, it started making me, and even Skittles. I mean, sometimes they're marketed towards kids specifically, but some of those candy products are actually more generic in their marketing. But definitely in the holiday, or if there's some sort of promotion that does happen, and those are not marketed towards kids, they're marketed towards adults.
Okay, thank you.
Diana, you should be able to unmute your microphone.
Thank you. Hello, Kevin. I'm Diana
Hi.
Carlin, representing Total Wine and More. Thank you for the opportunity. I appreciate you bringing us all together, and appreciate you receiving our comments. As has been, I think Carolyn just mentioned, a concern, of course, we have is that we are a large retailer that mostly just sells alcohol. So the current drafts of the rules are very challenging for us to implement. Not a lot of inventory that's non-alcohol related. So just the challenge with that, securing the minis, and that would be a significant portion of our inventory, very challenging. We do not have unaccompanied minors in our stores. And so just want to work with you to see if there's a way that we can have some sort of recognition of large retailers that are primarily serving or selling alcohol. Thank you.
Thank you for that, Diana. The topic did come up previously with regards to stores that only or predominantly sell alcohol, like Total Wine. And there, you know, there has been some discussion on a potential like safe harbor provision or something for stores like that. And some of the challenges there is that, you know, even though you don't allow unaccompanied minors into the store, I mean, that's a store policy. It's not a legal policy in the state of Washington. But that is something that has been brought up. You're bringing it up now. So, you know, we certainly want to consider that as we move forward with rules and look at ways that potentially we could, you know, address that in a way that works for everybody there. So thank you for your comments.
Thanks for that feedback.
Crystal, you should be able to unmute.
What is the time frame you would like feedback or recommended language by? And then what is the next what does the timeline for the either next round of draft language look like?
Well, one of the earlier slides that I showed had us tentatively shooting for a November filing date for the official rule proposal. So that again, that's tentative. This is not a legislative rulemaking, so we're not necessarily beholden to any rigid timeline to get it done. We want to engage in good faith with stakeholders and make sure we get it right before we put forth something as a proposal. With that in mind, I would just say the sooner the better. Certainly, if we can get feedback during the month of October, that will put us in a good position to hopefully move forward with something by the end of the year.
Tom, you should be able to unmute.
Hi, thank you, Tierney. Can you hear me?
Yes.
Thanks. Thanks, Kevin, for this opportunity. Tom Perrick representing alcohol producers. And we did have an opportunity to comment a couple of months ago. We'll take this information and provide additional comments as well after this stakeholder session. So I always appreciate the opportunity to engage with LCB. I just wanted to weigh in on, I'd heard one of the previous speakers mention that there are no states that require having products behind the counter. That is true for alcohol as well. Anything, 50 mLs, 100 and even down to 50 mLs. There are no states that require those products to be behind the counter. So the alcohol producers that I represent that make 50 mLs and above would be concerned about that. Certainly the expense of that from a retail perspective, that would be borne by the retailer. I think that would be an expensive proposition. Also, just want to be thoughtful about the definitions of reasonably secured. We see what you are attempting to do there in terms of reasonably securing these particular products. I would just note that things like theft prevention devices on a $4 or $5 50 ml is just not cost effective. It's just not going to happen. So that's going to impact sales. It's going to impact eventually state tax revenue as well. And then just thinking about something else I wanted to mention, just thinking about other displays in some stores. I just think it would be interesting if a 50 ml bottle of spirits would need to be locked up when other beverage alcohol that might be in a cold box that was available wasn't locked up. And the only difference there being size, one being a 50 ml, one may be a 200 or maybe a can of something else, one required to be locked up and another beverage alcohol not required to being locked up when it's in a cold box, kind of by a cash register as well. It's just an interesting and concerning kind of visual for me. At any rate, we'll continue to talk these things through. We've got several comments, Kevin, that we'll send forward and appreciate the time.
Thank you, Tom. Okay, kind of a lull here. Any other comments? I'll give it just a minute in case anything comes to mind. Of course, my laptop here is kind of freezing up on me. Wanted to get to the last slide here with the contact information.
Kevin, while you do that, we do have another question, and that is
Okay.
from Steve. Steve, you should be able to unmute.
Great, thank you. Unfortunately, I'm not able to see the presentation. I'm wondering if you're going to make that available, if you can send that out, or how we might be able to access that. Thank you.
Thanks, Steve. Yes, this the presentation is being recorded. It will be posted to our rules webpage. The links are over here in the chat. You can access it at lcb.wa.gov. And then we will also have probably like a PDF of this presentation. And all that should get posted probably by the end of the week after the second session, and if not, very shortly thereafter by early next week. All right. So again, if you have questions or comments, rules at lcb.wa.gov is the best way to get it to us. I did put in the chat over here, there's a link where you can access our rules webpage for all the pertinent information. And then also there is a survey about today's session that you can take that just helps us understand how we're doing, areas of improvement and that kind of thing. So feel free to take that and let us know how we can improve these stakeholder sessions. So unless anybody has any further questions, we'll go ahead and wrap it up today. I'll give it just maybe one more minute. Boy, a minute goes by really slowly when no one's talking. All right, I think that'll just about do it then. So we sincerely appreciate you taking the time today to help us draft these rules. Your feedback is critical for us to come up with something that works for everybody. So thank you so much for that. And we look forward to hearing from you further. Have a wonderful afternoon, everybody. Thank you so much.